Good afternoon, and welcome to the lunch for our convention, our 25th anniversary convention. And before we get to the main part of the program, which will have Al Regnery interviewing Attorney General Meese and Manny Klausner, it is my pleasure to start out by introducing you to one of the founding directors of the Federalist Society, and also the co-founder, and I believe still publisher, is that right, of the Harvard Journal of Law and Public Policy. You've seen, until just now, you've seen on the screens a whole series of the covers of the Harvard Journal of Law and Public Policy up there. The Federalist Society has had a close relationship with JLPP for its entire existence, and membership in the Society has always included a subscription to the Harvard Journal. Spence Abraham, from his position at the Journal, met with those who were starting the Federalist Society, and I guess in a way one could say they combined forces. As a result, when the Federalist Society was founded, he was a one of the 5 founding directors of it until his election to the United States Senate in 1994. And after his term in the Senate, he served as the Secretary of the Department of Education. He is Did I say education? Was energy the other department in addition to education that Reagan had wanted to eliminate? Sorry about getting those two confused. But anyway, without further ado, Spence is now head of Abraham Consulting Group, and without further ado, one of the people who's been key to the Federalist Society since its earliest days, the Honorable Spence Abraham.
Thank you, Gene. The truth is that President Reagan wasn't the only person who wanted to eliminate the Department of Energy. And on December 31st, 2000, when I was sort of in this period, having lost my reelection campaign for the Senate, and along with my wife was hoping that maybe there'd be a chance to serve in the federal government, we were about to end the old year somewhat depressed because I hadn't heard from anyone connected to the transition. I'd seen my name mentioned in the papers on several occasions as a potential candidate for the Department of Transportation because I was a Michigan senator and had served on the Transportation Committee in the Senate, but no word had been forthcoming. And then about 6 o'clock on New Year's Eve, we got a call at our home, and I picked up the phone. The White House operator was on and said, "Please hold for Mr. Andy Card." So, of course, now the chest is thumping and there's nervousness, either it's good news or bad. Andy Card comes on and says, "How are you doing?" I said, "Fine, how are you?" Back and forth for a while. Then he said, "I'm calling to see if you'd be interested in serving as Secretary of," at which point I said yes. And then it sort of hit me that energy and yes had crossed paths in the middle of the conversation. And so I said, "Andy," I said, "this is great. I'm excited. I'll do anything, et cetera, et cetera. There's just one little thing in my background I think you should know before we, make this public." And he said, of course, with all the trepidation one has these days in Washington when somebody says one little thing, he said, "What is that?" And I said, "Oh, it's just a little thing, very tiny, but it's, just something." And he said, "Okay, well, what is it?" And I said, "Well, along the way in the Senate, I just happened to be the co-sponsor of the bill to eliminate the Department of Energy. But otherwise, I think I'm really ready for the job, And so he said, at that point, sort of dead silence on the other end. My career now, sort of careening towards oblivion. And he said, "Well, I've got to talk to Governor Bush and call you back." So my wife and I sat staring at the phone for, the next 2 hours. The phone rang, finally, it was him, and he said, President-elect actually thinks it's kind of funny. So, of course, 2 weeks later, I had to appear for my confirmation hearing. And the first question that was asked was, "Do you still favor eliminating the Department of Energy?" "Oh, no, I don't anymore." So when did you change your mind? About 2 weeks ago. You know? I grew in office, and like so many others in this town, came to see the importance of large bureaucracies. So anyhow, that's a large bureaucracy story. Let me tell you about a small one. And Gene, it's very nice to have me have a moment or two here. Before we started with live footage on these screens, of course, you did see the covers of many of the editions of the Harvard Journal of Law and Public Policy. And today, the story of the journal is, of course, a really positive and robust one. There are about 8,000 subscribers, making it, I believe, the second most widely distributed law review in the country. I think this year's editorial board is made up of 140 students at Harvard Law School, which is about 10% or more of the Harvard Law School student body. But it was not always as such. And in 1976, 1977 school year, a group of us, a very small at that time group of self-identified and publicly identified conservatives, thought that the somewhat unbalanced nature of publications at the law school not only made it difficult for us to participate in the legal discussion, but also sort of prevented anybody of conservative viewpoints from having much of an opportunity to publish in the marketplace of ideas. And so we conceived of the idea of a journal that would be a place in which conservative writers, writers from law school professorial ranks to philosophers to public officials, might have a place to publish. And we approached the dean of the law school, Dean Albert Sachs at the time, and unveiled our creative idea of having one journal among all the others at Harvard that would in fact print or publish a conservative view from time to time. His reaction was, of course, very surprising to us when he said, "I can't imagine allowing that to happen here." And, we would never fund an explicitly a publication that had an explicit political bias. So we said, gee, you've got all the different law reviews, and we had done a study, and over the previous dozen years, not one conservative-oriented piece had appeared in the Harvard Law Review, the Harvard Journal on Legislation, the Civil Rights, Civil Liberties Law Review, any of the other publications there. And so we tried very hard to change his mind. He said, no, Harvard would not provide funding. And so we went back to the drawing board and decided that perhaps we could find some support in this country for such a publication. And over the course of the next year, that was sort of my job. And happily, we were able to find and secure enough funding to publish a first edition of the journal in the 77-78 school year. And one of the truly most memorable and amusing meetings I've ever been part of in a lot of different aspects of my career, probably the most interesting, was going back the following fall and informing the dean that lo and behold, there actually was enough money and we did not need Harvard's money at all. At which point he said, well, you can't use the name Harvard. And we said, why would that be? He said, well, it might associate our name, this institution's name, with topics and with content and with things that we don't think the name Harvard should be connected to. At which point we said, gee, there's like the Harvard House of Liquor down the street here, and that seemed like, if you're letting it go that far, there's the Harvard House of Pizza, there's, quite a few others, and he said, no. And so we then went into sort of a threatened legal challenge situation for a while, at which point ultimately he relented and let a happy band of about 11 law students, of which I was part, work during an entire school year to produce the first edition of the journal at the end of the 77-78 school year. And I would be remiss today if I didn't mention that the other co-chair and co-founder of the journal, Stephen Eberhard, who passed away tragically shortly after graduating from Harvard, was really more than anybody the bulwark that made this possible, because he really was the first editor-in-chief and by far one of the most amazing intellects I've ever known. And so I wish Steve were here today to see how this movement, in small part motivated by that journal and by a lot of other people. Steve was at the first Harvard or first Federalist Symposium, of how far we have come. And so I would conclude by just saying to the Harvard students of today, we thank you and are excited about the dramatic increase in the ranks. To all of you who are part of this society, we hope you enjoy the Harvard Journal of Law and Public Policy, and we're very excited at how far it's come. And to the people who have built the Federalist Society, to Gene in particular, Leonard, and the others on the team, I just want to say thank you for the great working relationship we've had between the publication and the Society. It's been great to be part of the team. Thank you.
Thank you, Spence. That was wonderful. I don't think I actually knew a large part of that story, so I enjoyed it a lot. I now want to ask our panel to take their seats. And I'm going, as they do that, I'm going to turn this over for the rest of the program to Al Regnery, who has a very deep pedigree in the conservative movement. His father published most of the books on most of the books on conservative ideas that you are certainly most of the authors that probably most of you know of. All of them in the modern American conservative movement. I think
they're going to turn it on.
Up and down the line. I think you pretty much got every one of them at one stage or another. And Al himself worked for years at Regnery Publishing, running it after his father's retirement, and now is the publisher of the American Spectator. He's just written a book, and I actually don't know the title, but on the American conservative movement. What is the title, Al?
The title's Upstream: The Ascendance of American Conservatism.
And it makes him ideally suited to do this interviews, and I'm going to turn it over to Al. Al Regnery. Al?
Thank you very much, Gene. I should say at the beginning, as Gene said, I just finished writing this book, which will be published in February, and having published many books myself, one of the things that I always told authors was whenever they had the chance, they had to plug their book. So it is up on Amazon. The title is Upstream: The Ascendance of American Conservatism. You can order it now, and it'll be shipped when it's published. What we're going to do is really interview Ed Meese about the last 25 years. And I know that you've heard a good deal about the last 25 years over the last couple of days. If any of you deign to read the Washington Post, there was actually a fairly nice story for the Post on Thursday about or Friday I guess it was, about the last 25 years of the Federalist Society. At least it brought up a good many of the things that have happened. I certainly cover it in my book. I think that the rise of this movement of lawyers, of the gathering of this many conservative lawyers is one of the great pieces of the growth of the conservative movement in this country. Certainly when the Federalist Society was started in the early 80s, about the same time that Ronald Reagan came to Washington, there were lots of things happening that conservatives recognized needed to be fixed. One of the principal ones certainly was the courts. The law schools obviously were no small part of that. Ronald Reagan, as Ed will tell us, recognized what those issues were with Ed Meese at his right hand. It certainly had a great deal to do with what happened. But all of these things came together at the same time to some extent. And the result is that this organization of lawyers was started in the early 80s, grew as time went on, and has had an enormous influence. And as I say, I think that it is probably the brightest aspect of modern American conservatism that there is. Let me start, Ed, by asking you sort of a question that relates to that. What was happening in the 80s has been described as the perfect storm. And that you had all of these issues coming together at the same time. It was the same time the Federalist Society was started. I wondered if you could elaborate on that a little bit and tell us how that perfect storm got started and what happened.
Okay, Al, I'll be happy to. Is this on?
Yes.
Yeah. It was kind of interesting when Gene Meyer asked me to participate in this panel to learn that I'd become an historical artifact. But in any event, I do appreciate the chance to talk about this, because as we discussed earlier today with the group, it's important to get the record of what really happened in the 80s well known, particularly among some of the younger people that are here and among students in the Federalist Society, because we want to get the accurate story out before the revisionists set in and try and change it. There have been a couple of articles in the paper that have already started. And so, but actually what happened, as you point out, Ronald Reagan came to office, of course, in 1981. One of the things he was most concerned about was, frankly, judges and judicial activism. He had had a record in the 1960s and early 1970s of appointing some of the best judges in California history, and was acknowledged to have done that by people, both Republicans and Democrats. He followed a governor then who had appointed almost everyone that he ever knew as a crony to the bench in California, even to the point of having a number of appointments literally down to the last day in office. That was the reason why Ronald Reagan took the oath of office at midnight that day, so that the first day that he could, so that he would stop this cascade of let's say, charitably political appointees to the California bench. So it was a matter of interest for him for a long time throughout his executive career in government. And so he was very much interested in this and had given talks about judges and the kind of judges he thought we ought to have. Secondly, we had the start of the Federalist Society in 1982, so that there was now an increasing group of people who were interested from the law schools, students in the law schools, an occasional professor here and there, and even by that time now people who were entering into the law profession. And then we had in the Department of Justice a number of very bright people, including 3 of the founders of the Federalist Society, as well as others, who were interested in this whole subject of constitutionalism, originalism, and topics such as this. We had, it was interesting, Ronald Reagan was accused of denuding the law schools of every professor who believed in the Constitution by putting them on the appellate bench. People had in mind particularly Bob Bork and Nino Scalia, people such as that, Ralph Winter and others, later on Frank Easterbrook and many others. But in any event, there was a great deal of interest in the Justice Department, and at the suggestion of some of those people, we created a series of seminars which produced, one, two. Under Steve Markman's direction, what were called the Blue Books, because they took the various topics of constitutional government and on the basis of the seminars we had, put that information into these Blue Books. So it was a combination of what was going on in the Department of Justice, the President's encouragement and motivation, and the Federalist Society all coming together that created what you accurately described as the perfect storm.
Okay, let me just go back on that same topic for a moment. In 1968, when Nixon ran for president, he campaigned on, well, one of his big topics was judges. And I think what the term he used then was strict constructionist. He wanted strict constructionist judges. And it's my contention that he had really no idea what that meant. If he did, it certainly wasn't manifested in the people that he appointed. After all, the 4 members of the Supreme Court he appointed, 3 of them, if nothing else, voted in favor of Roe versus Wade. And I guess Rehnquist was the only one who was really a conservative, and I think that was probably just because of the luck of the draw. Now, when you came to the White House with Ronald Reagan, Ed, you were not relying on the luck of the draw to get conservative judges. Can you tell us what you did?
Well, we weren't relying on the luck of the draw. We were really looking for people who believed in the Constitution and fidelity to the Constitution. And so my predecessor, William French Smith, and then when I became Attorney General in 1985, continued and expanded the idea of looking into the background of judges with extreme care. I think the mistake that President Nixon made was primarily relying on the ABA for good professional lawyers to be judges without really looking into or inquiring into what their views of the Constitution happened to be. And that was one thing that we stressed. beside the usual thing, the FBI background check, the checks with judges before whom lawyers had served, or looking at writings of law professors, things such as that, we had extensive interviews of everyone who, before the name was sent over from the Department of Justice to the President. And that included an interview with at least 3 and often as many as 6 assistant attorneys general or top people in the Justice Department, so that they could really inquire into this person's convictions, commitments, or even understanding or even having thought about the Constitution as a part of being a judge. And I think that was one of the things, this extensive background check on judges that was very helpful in presenting judges to the President for his selection and appointment, who really believed in adhering to what the Constitution actually said and not substituting their own political prejudices or policy preferences for what the Constitution said. Now, I must hasten to say that the record shows that this system was not absolutely perfect. And there have been occasions when individual appointees of Ronald Reagan, including on the Supreme Court, have not been as constitutionally faithful as one might have liked. But I think for the most part, it certainly went a long ways towards achieving the goal of having judges who believed in taking the Constitution and statutes as they actually read.
And the Federalist Society, of course, has helped change the terms of the debate in terms of what kind of judges are we looking for, of those that look worthy. How do they participate in a robust discussion? How do they get informed and get mutual reinforcement? And here the Federalist Society has played a major role. I do want to mention that Al Regnery and his father played a major role in the early days of scholarship, and that is Regnery Publishing Company published books by one of my law professors, Sylvester Petro at NYU. He wrote The Labor Policy of the Free Society, a grand statement of limited government, personal liberty, and property rights. And Petro was a major influence on me when I was in law school. He introduced me to Ludwig von Mises, who was then teaching at the Graduate School of Business at NYU. He never could get a permanent appointment, but he was a visiting fellow financed by the Olin Foundation. And I had the privilege of studying with Mises. When Petro went to Italy on a sabbatical, I took over a seminar that he was giving for the law students. And I had various people from Murray Rothbard to Henry Hazlitt and others come to NYU Law School in the early 60s for a robust discussion of not merely conservatism, but conservatism, the free market, and libertarianism. And this is where Al's book, I think, may be deficient. I haven't read it yet, but I gather if it's the ascendancy of conservatism, he may not have yet in the sequel that he probably will have, is every conservative who takes liberty seriously ultimately becomes a libertarian.
Well, let's go there for a minute. The Federalist Society, probably more than any other conservative group, prides itself on having both conservatives and libertarians. Maybe you could talk about that for a minute and talk about the strength that it brings to the society and how those points of view differ and how they merge.
This, I think, is one of the hallmarks of the contribution of the Federalist Society. Its leadership, its organization, its literature, its website, the debates, the programming. It's a robust discussion with libertarians and conservatives, but also in the debate aspect. When I was early on involved with the Libertarian Party, Libertarian Party put on the best conferences in town because we had really skilled, thoughtful people from all areas, libertarians, conservatives, and liberals. And the Federalist Society has done it much better. So I'm happy to see that as the Libertarian Party has somewhat declined, the Federalist Society is ascending. And when I interviewed Ronald Reagan for Reason magazine in the 70s, Ronald Reagan said, the heart and soul of conservatism is libertarianism. And he was truly a believer, far more articulate and insightful than many people in politics or in academia then and since. Now we have the benefit of young scholars, many of whom are members of the Federalist Society, from Randy Barnett to not just young scholars, from Richard Epstein. We have a lot of really thoughtful people who are developing an appreciation of what the Constitution really intended to do by preserving not just oases for liberty in a sea of statism and regulation, but as Randy Barnett points out, this sea, the ocean, is liberty. The oases are the restriction and statism. And I think that paradigm is being produced and fostered by the extraordinary intellectual discussion that we have at these events, which bring people from all over the country and from Europe and Asia to get in a dialogue. And that's the essence. Look, as a founder of Reason Magazine and a founder of the Reason Foundation, we've always felt that the role of Reason was to preserve a framework for intelligent discussion of people who are devoted to limited government, minimal taxation, and take liberty seriously. And that's what the Federalist Society does, and it does it with such gusto that we can look here and give thanks shortly before Thanksgiving. What this organization has turned into, it's really extraordinary.
I think Manny has a very good point, because there were always conservative and libertarian lawyers around in the country, but it really wasn't until the Federalist Society that they had a way in which to come together and express their views. I mentioned the other night when we were talking there at the banquet that many of the law school deans that I met as I was going around the country after I had left the government, many of the law school deans, who almost all of them liberal, pointed out how much they appreciated the Federalist Society because apparently for the first time they had brought debate to their particular campuses. And it's an interesting thing since the legal profession is well known for the ability of lawyers to articulate their views, but they just didn't have the fora in which to do it. And that's why the Federalist Society has been so valuable, both on campuses of law schools, but also in terms of the legal profession generally.
We're going to come back to law schools in a minute, but let me raise this other point, and that is that as I've studied this conservative movement, it's interesting how in virtually every case of the growth of part of it, you can trace it back to something somebody wrote, somebody published. And I guess what it says is that, as you all know, this is a movement of ideas, and ideas have an enormous strength. Richard Weaver, of course, wrote the famous book, Ideas Have Consequences, and never was a truer statement made. Certainly what Reason Magazine does is to introduce people to ideas that prevail. And in the case, I want to come back to judges for a minute. In 1972, Bob Bork wrote a law review article in the Indiana Law Review on the appointment of judges. And incidentally, let me just say that again, as I look at it, I don't think there's anybody that is more central to what we believe and what we're doing today than Bob Bork.
Yeah.
But Ed, I wonder if you could comment on that law review article. I'm sure you've read it and you're familiar with it. It was written 8-9 years before Ronald Reagan came to town, and back when things were pretty grim, actually, in terms of the way judges were picked and confirmed and so on. Did that law review article have some influence?
Well, it certainly did, and I think that that article, not only in setting forth what the situation was, but also articulating what judges should be doing and how they should be faithful to the Constitution, was an important background, literary background for the kinds of things we were thinking in our administration and in the Justice Department, and ultimately gave way to some of the speeches that took place during the 1980s and some of the writing that we did. I guess you are talking about particularly the speech of the American Bar Association, which came to a great extent out of the ideas expressed in that law review. In 1985, the American Bar Association, at that time not particularly noted for its conservative views, had its the kinds of conventions that they had only about every 16 or 17 years, when they would have one session in Washington, D.C., and then go to London for the second half of the same session. And so a group of us were sitting around. I'd been invited to give a talk there as Attorney General, And we had, Steve and I were talking about this at lunch, Steve Calabrese, John Harrison, Dave McIntosh, Terry Eastland. It's interesting that almost all the people sitting in that group, Ken Cribb, Brad Reynolds, are all part of the Federalist Society, just by a curious coincidence. And so we decided that the speech ought to be more than welcome to Washington, but really talk about something substantive. And that was the speech in which we talked about a jurisprudence of original intent, and specifically talked about some of the decisions of the Supreme Court in the session that had just been completed, in which in the area of religious liberty and in criminal law, and I believe property rights, the law became even further muddled than it had been before, and how, pointing out in the speech that with a lack of a constitutional anchor as the basis for principled jurisprudential decisions, that the Supreme Court wandered all over in all directions, and that was why consistency and faithfulness to the Constitution was so important. Well, as you know from history, like most speeches given to the ABA, that would have never been heard from again, except for the fact that Justice Brennan took umbrage at this, at the fine work that he had led, and as a result, he gave a speech at Georgetown Law Center in which he attacked this point of view, the idea that people should really look at the Constitution for the basis for their decisions was somehow anathema to him, and therefore he gave this speech. Well, fortunately that he gave that speech, as I say, that was the greatest thing that ever could have happened to us. And the Federalist Society then took those two speeches and put them together in a book along with some other speeches. And that really started a lot of the whole intellectual discussion about this whole subject of originalism.
Check, 1 2 1 2.
And of course, the debate is ongoing and robust. And this is, again, there's no scholar that any of us have encountered who's omniscient and doesn't need intellectual stimulation, no matter how far advanced the ideas. And what we see here is the synthesizing and the advancement of ideas of liberty. One of Ed's good friend was a good friend of mine, Bernie Segan, who alas didn't get confirmed for the Ninth Circuit, authored one of the significant books on the importance of constitutionalism and the American Constitution protecting economic liberties and property rights. And there are many people here, Alex Kaczynski is here and others who have followed and carried that torch, but it's not enough to have good vetting and careful selection as is critical. It's not sufficient. What you need to have is an ongoing, robust examination and continuing evolution. If we look at the Abigail Alliance case, we have interesting judges who do take liberty seriously on both sides of a constitutional decision, whether somebody who has a terminal disease should be allowed to take an experimental drug if the FDA doesn't feel it's ready to grant a certification yet. Is that a fundamental liberty in America, or is it an essential part of the liberty that we have as Americans under the Constitution? This is a serious debate that's ongoing. It doesn't get a better airing and a better understanding than in the circles of the Federalist Society, where people have different views on it. And that also I wanted to mention, beyond judges, the front lines of public interest law for years has been a very aggressive, active group of people doing their best to advance the social agenda that was absolutely repugnant to the issues of limited government and private property. And that has been transformed tremendously. We just recently celebrated, a couple of years ago, the 35th anniversary of the pro-liberty, pro-property rights public law movement in America. Ed has been involved in holding with a lot of Federalist Society people involved, holding biannual, or I guess semi-annual meetings, the legal strategy forums, with leading public interest lawyers from around the country. The Pacific's Legal Foundation is given due credit for extraordinarily being a milestone and a landmark institution, but we have many other groups. Actually, the original public law institution that believed in limited government in the specialized area of labor relations and union shops was the National Right to Work Foundation, which Sylvester Petro is involved with. So we have this great tradition. If you look across the room here, there's a lot of people that have been doing public interest law, and many law firms that are now allowing lawyers, with a little bit of pressure and difficulty sometimes here and there, allowing the lawyers to do pro bono work that isn't merely advancing big government. And that's, the Federalist Society has had, again, a major impact in that.
Yeah.
Well, let's talk about that for a minute. Ed, let me ask you, reminisce back before 1982, 1981, when the left really had control of the public interest movement, public interest law movement. There were countless, I can't remember how many, I do know, I've seen the number of people that were involved in it, but it was a tremendous number of lawyers. And incidentally, when I went to the Lands and Natural Resources Division at the beginning of the Reagan administration, the guy that had headed that division during the Carter administration had been the chief counsel of the Sierra Club before, and that was the kind of thing they did. I mean, he was settling cases with his former partners the way he wanted them settled. But talk about it for a minute, if you would, how grim things were in those days before our people came along.
Well, what you had, and the peculiar and major source of revenue for all of these so-called public interest law firms that were bringing these lawsuits, and they were lawsuits usually against law-abiding citizens, taxpayers, small business people, things such as that. They were all funded by the federal taxpayer. And public interest law as a group was these various programs that had started during the so-called war against poverty of Lyndon Johnson, when the Office of Economic Opportunity started all these law firms around the country that were bringing these lawsuits. So what you had was liberal presidents appointing very liberal judges, and then you had these taxpayer-funded so-called public interest law groups teeing up the issues for these judges to then move to the left on. And so you had, there you had kind of a perfect storm of a different sort, which was the combination of taxpayer-paid lawyers providing the basis for judges to make anti-constitutional decisions, particularly in the field of property rights, and economic justice, things such as that, which was an almost wholesale assault on business and property and things such as that. So this was the conditions really that we came into, and that's why we had just a few organizations that started to counter this, the first one being the Pacific Legal Foundation, which was really the answer to one of the major sources of these cases, which was when Ronald Reagan had the welfare reform program, the most successful program of its time in California in 1971. These taxpayer-funded organizations brought all the lawsuits to stop the welfare reform. Certainly not something that was fighting poverty. As a matter of fact, what it was doing was really taking away forces that were helping to deal with the problem of poverty, and was actually perpetuating poverty in California. The California Rural Legal Assistance was one. There were a number of others. And so this was the situation that was faced, and why it was so important for the freedom-based public interest law movement to come into existence.
And until they did come into existence, of course, if there was any opposition, it was scattered here and there. It was an article in National Review or Human Events or something like that, but there really wasn't any way of coalescing people that would oppose it until this came along in the Federalist Society. Can you comment on that?
Well, the public interest law movement has been very important, but just generally, I think, beyond the frontline lawyers who are involved in groups like Institute for Justice, which is the prototypical law firm that understands how to find good cases with good plaintiffs on good issues and work their way up to restoring a recognition of economic liberty under the Constitution. Not easy to do, as we know. And the Abigail Alliance case is sort of a big step in this process of giving individual consumers the right to control their bodies, their medication. Now, it's one of the interesting tensions within libertarians and conservatives, and we see this in the legal strategy meetings that we have with the pro-liberty freedom, pro-liberty public interest law firms, is that we have sitting peacefully, civilly, and having meaningful discussions among conservatives and libertarians who sometimes file amicus briefs on the opposite sides of issues, like the Reich medical marijuana case, or like some of the gay rights cases or other cases. It's kind of an interesting, friendly discussion where we agree on core issues, and there's some issues where we have some significant disagreements, but always very civilly. And we've seen an educational process in the Corps for those who really believe that government in a free society should leave people alone to preserve their talents, to maximize their abilities, to choose their livelihood, to not have to get a license, do not have to get government approval to publish something, to be able to go to get admitted to college or law school without regard to your race or your ethnicity or your sex. These are issues high on the agenda for those lawyers who I think most of us share. We take these ideas seriously. And there are some areas where we disagree, but the body and the strength, I think, of what we've done is forge this extraordinarily powerful coalition that when a case comes up, we have a network of lawyers to connect with. The Federalist Society Pro Bono Project has been extremely helpful in finding and identifying and recruiting good lawyers from major firms to assist on a pro bono basis in worthy cases. This is something that didn't happen 30 years ago.
Well, that's certainly true, particularly the pro bono bit, which the Federalist Society has been so important in. We were talking earlier about a law student who wanted to get credit for working in a district attorney's office and went to the clinical program at his law school to see if he could get credit. And as was related to me by Steve, he could only get credit if he worked for the defense. But working for the prosecution for the public was not a source of credit. I think today even that is changing, just as it is in law firms. There was a time when pro bono work in a law firm meant working for some liberal cause. Today, thanks to, quite frankly, the quality of the lawyers that are represented here, the fact that many law firms are now changing their policy, and any pro bono work, including that advances the cause of liberty, is also being recognized by many law firms.
Not yet in San Francisco, probably.
Well, there's a lot that's not recognized in San Francisco, and a lot that is that we wouldn't recognize here.
Well, why don't we turn our attention for a moment to the law schools? We talk about ideas, and of course in the law, many of the ideas in any part of it are originated in law schools, the law reviews. I think in my book I mentioned that until about 1981 or 1982, the law schools basically were owned by the left wing. You heard Spence Abraham talk about the problems that he faced when he started his journal at Harvard. I know you've all heard about the first meeting of the Federalist Society and what probably a good many of those people encountered when they got back to their law schools, having been accused of being crazy or whatever. Ed, talk to us for a minute about what happened as the Federalist Society began to start chapters in law schools and how that began to contribute to this change that's happened.
Well, I think in order to understand the change that took place, you have to go back to some of the pioneers. And one pioneer who even was in advance of the Federalist Society was Bernie Segan. He was undoubtedly one of the great champions of liberty, as Manny has pointed out. But he also was a very respected law professor at the University of San Diego. And he alone, I think, with the help of perhaps of a couple of others there, changed the climate of that university so it was accepted. It accepted other ideas. I know from personal experience because they accepted me as a professor, and that was a very good experience. There were some other law schools that at least would tolerate people of a constitutional or conservative persuasion, but they were very few and far between, and the Harvard experience was much more alike. It was probably all right if they had one on the faculty. They could teach a course as long as they didn't try to influence student opinion too much. But what really came about, largely starting in 1982, was an institutional way of students to organize and increasingly, with a very small start, professors to participate in something where they could join together with students and professors from other schools and indicate that there was really other people who thought like them and that they weren't aberrant, strange people in this law school where they happened to be. And so this is particularly true of professors, but it was also to a great extent true of students. And of course, one of the things that I think helped the Federalist Society expand was the natural rebellion of young people. And having listened to the liberal dogma throughout most of their law school days, there was kind of a natural reaction to say there must be something more than this. And I think that was one of the kind of spirit that permeated the people who got together in the Federalist Society and was the catalyst for a lot of the enthusiasm, because all of a sudden there was this idea of having debate, of having differing views expressed, and for people who had different political ideas, the privilege of being able to express them without being exiled to some sort of a corner of the law school for idiots and other people who just didn't understand.
How about law and economics? Law and economics was getting started about the same time as the Federalist Society, maybe even a little bit earlier. It was a movement that the Olin Foundation took on as one of its projects and spent a good chunk of its budget helping get started. You've probably had some contact with law and economics. To what extent did that movement help set the stage for what came later?
Another very indispensable element in the story that we're discussing here, and how we changed the legal culture. And part of changing the legal culture was to understand the impact of the law of supply and demand and the counterintuitive impact of laws that try to ignore the law of supply and demand. So what we have, I think University of Chicago, Henry Manny, Aaron Director, Ronald Coase came in the mid-60s to Chicago. The Journal of Law and Economics was being published from there. It came out once a year. When Aaron was editor, he was a few years behind, but Ronald Coase got it all caught up. I had the privilege when I was a big old fellow at Chicago and instructor on the faculty of working with Ronald Coase and helping bring the journal up to catching up. And also working with Ronald Coase in a course in law in price discrimination. That essentially, I think Henry Manny is one of the really undersung heroes. Henry went from University of Chicago to University of Miami. He was at Emory in between, and he has continued to contribute and to write. But one of the really important voices that many of us know and have been influenced by. Ronald Coase has been masterful in the whole the problem of social costs and his theoretical understanding of basically common sense approaches to issues that many law professors and other academics felt that they didn't need to worry about. We had basic landmark approaches to economic analysis that have now interfaced and interconnected with the law school curriculum. That's been a major impact. And again, there are a lot of people in this room that have seen it evolve or participated in the evolution and the growth. And that's something the Federalist Society has, again, played a major role in, and we can see that from the people in this room.
Good. I was chatting with Gene Meyer one day some time ago, and he mentioned that there were a lot of issues that if they were not raised by the Federalist Society in law schools, they simply wouldn't be raised. And I think that's a very good point. You know, in any philosophical movement, there are sort of two factions in a way. There are those people that set the agenda, and then those people that live on the agenda that other people set. And I think a comment like that of yours, Gene, indicates to me that the Federalist Society is setting the agenda. Ed, could you talk about that?
Sure. I think that what the Federalist Society has done is provide a way for a lot of the issues to be raised, as you point out, and also for people to be respectable in taking positions that are almost unknown among most faculties. I think one of the most important, of course, was equality under the law and the efforts against racial discrimination in admissions and promotions in law school. And this is one in which it was now respectable in debate through the Federalist Society to have a debate on this kind of subject, which led to really major changes in the law school. Now they use terms like diversity and they try to get around it as much as possible, but you still have the Federalist Society and others motivated by this idea of equality under the law to provide an opposing point of view when law schools try to do this. They even try to have an increase in diversity, and that is the diversity of ideas, and something that law schools have not been particularly famous for the most part. So I think that teeing up these ideas for debate in law school has been one of the things the Federalist Society does, again, by bringing in people from outside to debate them. and particularly in sessions such as this, both in the student symposium and in the lawyers conference, has been very successful. And one of the things that has been so important is that the Federalist Society has not been afraid to have both sides represented. We believe in the marketplace of ideas, and that if you have the best ideas, which we think are ours, you're ultimately going to win out when you have these kinds of debates. Nadine Strozen, the president of the ACLU, is here, for example, and has been a very good. Steve Reinhardt, hardly a believer in most of what people think here, is yet
in admissions in order to circumvent very clear prohibitions on doing what they think they can get away with anyway, because it's so important for them to forget about merit. And this is an area where Rick Sander at UCLA Law School has pointed out the costs. This is his serious empirical study. If you're not familiar with, you should be. The cost of having racial preferences and admitting minorities who are not equally qualified with their peers to law school results in, as we would expect, Abby and Steve Thernstrom have pointed the way, and others, you would expect if you're running an Olympic quality team and you can barely make the C team, that you're not going to do as well and you won't finish as well. And maybe you'll drop out of the race early, and maybe if you finish, it'll be after the clocks have already stopped timing. And in the case of law schools, there's been a significant racial gap in bar rate passage for minorities who are admitted on racial preference, lower admission standards than their classmates. Who benefits from that? This is one of the areas where the Federalist Society has been very helpful in helping expose and promote the understanding of the study. There's a lawsuit going on now. There's a panel I didn't go to, but I think there was one of our panels on the battle with the California State Bar examiners who are having a difficult time finding that it's appropriate to let Richard Sanders examine the data, race-based bar passage rate and failure rate data to continue his studies. And why, one might ask, is the Committee of Bar Examiners reluctant to let people understand the real costs of racial preferences?
It's interesting that you point out Ward Connerly's work in Michigan. It's very rare that the Supreme Court gets overruled and overturned, but they were by the people of Michigan in terms of that particular decision.
And I might add, Ward has had the benefit of having a number of Federalist Society lawyers work with him, initially in California. Gene Volokh, I've been involved, a number of other lawyers in drafting and campaigning for the initiatives, handling the litigation, and now we see there's always a need, if anyone's interested in looking.
Purview. Leonard Leo has been particularly active in this. I'm sure when he shows up at the ABA conventions, there's a considerable interest on the part of the officers about which sessions he sits in on. But it actually is the point, as Gene Meyer can tell you, where the president of the ABA came to sit down some years ago, started sitting down with the officers of the Federalist Society to try to develop some sort of a peace treaty, I guess you might call it, or in any event, to develop a rapport, because they recognize that the Federalist Society represents an intellectually capable and considerably large group of lawyers who have some strong opinions about what the ABA has been doing. And tonight you would find a Federalist Society background there. And this is one administration where you don't have to leave the Federalist Society off your resume. So I think that's been an important thing.
The ABA Watch was one of the great publications of the Federalist Society, and Leonard and Gene have had this extraordinary strategic vision and also been extremely clever on how they've gone about achieving our objectives. So what was the clever and original idea with ABA Watch? Well, it was calling for a publication that essentially would simply report in their own words what the ABA people were saying without any commentary.
Right. Yeah. You know, it's that old political maxim, you know, if you don't stop telling lies about me, I'll start telling the truth about you.
Let me digress just for a minute and tell you a quick story that I found to be most amusing, and that is, Ed mentioned Earl Warren, and we're talking about judges and how they get picked and how they get confirmed. It's very interesting how Earl Warren wound up on the Supreme Court, actually. He was, of course, the governor of California, and he was actually running for president in 1952. He'd been in a couple of primaries, and Eisenhower got to the convention. Taft actually had more delegates than Eisenhower did. Eisenhower was viewed as the one who could probably win, but Taft nevertheless was ahead. They were in the midst of the debate on the Brown versus Board of Education case, and of course the Supreme Court was tied in knots. They were split, and they couldn't come to a conclusion. And Frankfurt apparently said when he heard that Vincent died, he said, "My God," he said, "that's the first indication I've ever had that there is actually a God." Ed, you were involved in the recent Supreme Court confirmation battle with Chief Justice Roberts and Justice Alito, and there was obviously the Federalist Society itself wasn't involved, but there was a good Federalist Society presence, and I wondered if you could tell us a little bit about that and how that worked and the result and what the Federalist Society lawyers brought to bear that might not have existed when you first got to the Justice Department in the 80s.
I think if you want to look at this confirmation battle that we had and previous ones, I think you have to go back to what confirmations were like prior to 1987. And that was they were sometimes contentious, but they were always civil, and they were usually limited to the hearings before the Senate. In 1987, with the vicious and pernicious attack on Bob Bork, that was another perfect storm. The Democrats had just taken over the Senate. You had all of these very left-wing groups, special interest groups, that were spoiling for a scalp. And so you had all of this come together to attack Bob Bork and turn what had been used against a lot of the majority being used against those who've been nominated for federal appellate courts. But with the two Supreme Court positions in the confirmation process, it was very interesting that we had lawyers groups all over the country that were able to write in support, to express their support in the states of the key senators, which is so important, to write letters to the editor, things such as that. And it was the fact that there was an ability to get out information, and nothing more than information, leaving it to individual lawyers to make their own determination of whether they would be supportive or not, that the Federalist Society had that network to pass out the information. So I think that the keeping within its limitations as a nonpartisan organization.
Even if you have the moral high ground and the benefit of sounder positions on the Constitution, you can get outgunned sometimes. And so this national network of lawyers and Federalists who are involved in the vetting process and the writing articles and opinions and creating a climate of public opinion that lets people see that the judges that sometimes may be unpopular don't necessarily have horns and tails, and they really are pretty bright guys and have a lot to do with applying the rule of law in an even-handed way and really showing what the judicial system ought to serve in a free society.
There's another way also where the Federalist Society performs a function, and that is providing a platform for these judges and justices to be heard once they've been appointed and confirmed, which is sessions such as we've had here. As you know, it's very easy for liberal judges to appear before a lot of audiences and get great acclaim. There are far fewer audiences for the kinds of judges and justices that we've had here. And so this also is, I think, a very important way of providing a platform, but also having a group of lawyers as large as this providing support and letting these judges and justices know that there is a great body of the legal profession out there that believes as they do and wants to support them in their constitutionally oriented decisions. They picked a rather curious name because it ought to be the American Anti-Constitution Society. They could actually, if they just called it the Anti-Constitution Society, they could keep the same initials. But I think that in a way, perhaps it's a good thing to have this in law schools, because then it will further the debate. And as I said before, in the marketplace of ideas, I'm confident that our ideas are going to come out ahead. But I think that there's no question in my mind that, as you point out, Al, there really are no ideas, no new ideas on the left. All they are is anti-something. For now, all they seem to be able to talk about is being anti-George W. Bush. But they're
A robust icon and still continues to do so much so ably. So, and I'd like to just mention, in terms of where we're going from here, one of the essential areas that I think is urgently in need of major structural reform is the public school institution in America in virtually every major city, which is a cesspool for any inner city kids, and is not teaching even kids from good neighborhoods in affluent areas. People are not being grounded. It's very much still a system for indoctrination, let alone not learning how to read and write, those that are functionally literate, which leaves out a lot of the kids that start.